Mr. Chief Justice, let me answer that, and then, if I may, I'd like to move to the tax power argument.
Can I tell you what the something else is, so while you're answering it? The something else is everybody has to exercise, because there's no doubt that lack of exercise causes illness, and that causes health care costs to go up. So the federal government says everybody has to join an exercise club. That's the something else.
No, the position we're taking here would not justify that rule, Justice Scalia, because health club membership is not a means of payment for consumption of anything in a market.
Right. That's exactly right. But it doesn't seem responsive to my concern that there's no reason, once we say this is within Congress's commerce power, there's no reason other than our own arbitrary judgment to say all they can regulate is the method of payment. They can regulate other things that affect this now conceded interstate market in health care in which everybody participates.
But I think it's common ground between us and the respondents that this is an interstate market in which everybody participates, and they agree that Congress could impose the insurance requirement at the point of sale. And this is just a question of timing and whether the necessary and proper authority gives Congress, because of the particular features of this market, the ability to impose the insurance, the need for insurance, the maintenance of insurance before you show up to get health care rather than at the moment you get up
to
I think
you're just,
get health care.
Unless I'm missing something, I think you're just repeating the idea that this is the regulation of the method of payment. And I understand that argument.
And
it may be a good one, but what I'm concerned about is once we accept the principle that everybody is in this market, I don't see why Congress's power is limited to regulating the method of payment and doesn't include, as it does in any other area. What other area have we said Congress can regulate this market, but only with respect to prices, but only with respect to means of travel? No, once you're in the interstate commerce and can regulate it, pretty much all bets are off.
But we agree Congress can regulate this market. ERISA regulates this market. HIPAA regulates this market. The market is regulated at the federal level in very significant ways already. So I don't think that's the question, Mr. Chief Justice. The question is there a limit to the authority that we're advocating here under the Commerce Power? And the answer is yes, because we are not advocating for a power that would allow Congress to compel.
Could you just say, before you move on, could you express your limiting principle as succinctly as you possibly can? Congress can force people to purchase a product where the failure to purchase the product has a substantial effect on interstate commerce if what? If this is part of a larger regulatory scheme? Is that it? Is there anything more?
We got two, and they're different. Let me state them. First, with respect to the comprehensive scheme. When Congress is regulating, is enacting a comprehensive scheme that it has the authority to enact, that the necessary and proper clause gives it the authority to include regulation, including a regulation of this kind, if it is necessary to counteract risks attributable to the scheme itself, that people engage in economic activity that would undercut the scheme. It's very much like Wickard in that respect, very much like Raich in that respect. With respect to considering the Commerce Clause alone and not embedded in the comprehensive scheme, our position is that Congress can regulate the method of payment by imposing an insurance requirement in advance of the time in which the service is consumed, when the class to which that requirement applies either is or virtually will certain to be in that market, when the timing of one's entry into that market and what you will need when you enter that market is uncertain, and when you will get the care in that market, whether you can afford to pay for it or not, and shift costs to other market participants. So those are our views. Those are the principles we're advocating for, and it's in fact the conjunction of the two of them here that makes this, we think, a strong case under the Commerce Clause.
General, could you turn to the Tax Clause?
Yes, thank you. So
I have looked for a case that involved the issue of whether something denominated by Congress as a penalty was nevertheless treated as a tax, except in those situations where the code itself or the statute itself said treat the penalty as a tax. Do you know of any case where we've done that?
Well, I think I would point the Court to the license tax case where it was denominated a fee and not a tax, and the Court upheld it as an exercise of the taxing power in a situation in which the structure of the law was very much like the structure of this law, in that there was a separate standalone provision that set the predicate and then a separate provision imposing the fee.
But fees, license fees, fees for a hunting license, everybody knows those are taxes. I mean, I don't think there's as much of a difference between a fee and a tax as there is between a penalty and a tax.
And I think in terms of the tax power, I think it's useful to separate this into two questions. One is a question of characterization. Can this be characterized as a tax? And the second, is it a constitutional exercise of the power? With respect to the question of characterization, this is in the Internal Revenue Code. It is administered by the IRS. It is paid on your Form 1040 on April 15th.
But yesterday you told me you listed a number of penalties that are enforced through the tax code that are not taxes, and they're not penalties related to taxes.
They may still be exercises of the taxing power, Justice Ginsburg, as this is, and I think there isn't a case in which the Court has to my mind, suggested that anything that bears this many indicia of a tax can't be considered as an exercise of the taxing power. In fact, it seems to me the license tax cases point you in the opposite direction, and beyond that, it seems to me the right way to think about this question is whether it is capable of being understood as an exercise of the tax power.
The President said it wasn't a tax, didn't he?
Well, Justice Scalia, there's two things about that. First is, it seems to me what matters is what power Congress was exercising. And I think it's clear that they were exercising the tax power as well as...
You're making two arguments. Number one, it's a tax, and number two, even if it isn't a tax, it's within the taxing power. I'm just addressing the first.
What the President said...
Is it a tax or not a tax? The President didn't think it was.
The President said it wasn't a tax increase because it ought to be understood as an incentive to get people to have insurance. I don't think it's fair to infer from that anything about whether this is an exercise of the tax power or not.
Well, isn't the tax is to raise revenue? A tax is a revenue-raising device, and the purpose of this exaction is to get people into the health care risk pool before they need medical care, and so it will be successful if it doesn't raise any revenue, if it gets people to buy the insurance. That's what this penalty is. This penalty is designed to affect conduct. The conduct is buy health protection, buy health insurance before you have a need for medical care. That's what the penalty is designed to do, not to raise revenue.
That is true, Justice Ginsburg. That is also true of the marijuana tax that was upheld in Sanchez. That's commonly true of penalties under the Code. They do, if they raise revenue, they are exercises of the taxing power. But their purpose is not to raise revenue. Their purpose is to discourage behavior. The mortgage deduction works that way. When the mortgage deduction it's clearly an exercise of the taxing power. When it's successful, it raises less revenue for the federal government. It's still an exercise of the taxing power. So
I suppose, though, General, one question is whether the determined efforts of Congress not to refer to this as a tax make a difference. I mean, you're suggesting we should just look to the practical operation, we shouldn't look at labels, and that seems right, except that here we have a case in which Congress determinedly said this is not a tax, and the question is, why should that be irrelevant?
I don't think that that's a fair characterization of the actions of Congress here, Justice Kagan. On the December 23rd, a point of constitutional order was called too, in fact, with respect to this law. The floor sponsor, Senator Baucus, defended it as an exercise of the taxing power in his response to the point of order. The Senate voted 60-39 on that proposition. The legislative history is replete with members of Congress explaining that this law is constitutional as an exercise of the taxing power. It was attacked as a tax by its opponents. So I don't think this is a situation where you can say that Congress was avoiding any mention of the tax power. It would be one thing if Congress explicitly disavowed an exercise of the tax power, but given that it hasn't done so, it seems to me that not only is it fair to read this as an exercise of the tax power, but this Court has got an obligation to construe it as an exercise of the tax power if it can be upheld on that basis.
Well, why didn't Congress call it a tax then?
Well,
You're telling me they thought of it as a tax, they defended it on the tax power. Why didn't they say it was a tax?
They might have thought, Your Honor, that calling it a penalty as they did would make it more effective in accomplishing its objectives, but it is in the Internal Revenue Code. It is collected by the IRS on April 15th. I don't think this is a situation in which you can say...
So that's the reason. They thought it might be more effective if they called it a penalty.
Well, there's nothing that I know of that illuminates that.
General,
Certainly.
the problem goes back to the limiting principle. Is this simply anything that raises revenue Congress can do?
No. There's certainly
so there has to be a
limiting
limiting
under the tax
principle
power,
as to when...
and I think, of course, the Constitution imposes some. It's got to be uniform, can't be a tax on exports. If it's a direct tax, it's got to be apportioned. Beyond that, the limiting principle that the Court has identified from Drexel Furniture to Kurth Ranch is that it can't be punishment, punitive, in the guise of a tax. And there are three factors the Court has identified to look at that. The first is the sanction and how disproportionate it is to the conduct. The second is whether there's scienter. And the third is whether there's an administrative apparatus out there to enforce the tax. Now, in Bailey against Drexel Furniture, for example, the tax was 10% of the company's profits, even if they had only one child laborer for one day. There was a scienter requirement, and it was enforced by the Department of Labor. It wasn't just collected by the Internal Revenue Service. Here, you don't have any of those things. The penalty is calculated to be no more than, at most, the equivalent of what one would have paid for insurance that you've foregone. There's no scienter requirement. There's no enforcement apparatus out there. So
can the mandate be viewed as a tax if it does impose a requirement on people who are not subject to the penalty or the tax?
I think it could, for the reasons I discussed yesterday. I don't think it can or should be read that way. But if there's any doubt about that, Your Honor, if it is the view of the Court that it can't be, then I think the right way to handle this case is by analogy to New York against the United States, in which the Court read the shall provision, shall handle low-level radioactive waste, as setting the predicate, and then the other provisions were merely incentives to get the predicate met.
So you're saying that all the discussion we had earlier about how this is one big uniform scheme and the Commerce Clause, blah, 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 it really doesn't matter. This is a tax, and the federal government could simply have said, without all of the rest of this legislation, could simply have said, everybody who doesn't buy health insurance at a certain age will be taxed so much money, right?
It used its powers together to solve the problem of the market not providing
but you didn't
affordable
need
coverage.
that. You didn't need that. If it's a tax, it's only raising money is enough.
It is justifiable under its tax power. If I may reserve the balance of my time.
Thank you, General. We'll take a pause for a minute or so, Mr. Clement. See. All right, why don't we get started again? Mr. Clement.
Mr. Chief Justice, and may it please the Court, the mandate represents an unprecedented effort by Congress to compel individuals to enter commerce in order to better regulate commerce.